So the Claremont County Municipal Court has severely damaged its moral and ethical authority. In 2023, it came to light that Judge Jesse Kramig was effing his hot assistant in and out of the courthouse. When it came to light, it was covered up by court personnel and even a judge, Judge Nagel. Later, in summer of 2024, Judge Kramig was caught in a parking lot with his hot assistant and then finally resigned. The court has done a lot to damage itself and its own reputation. I have lawyers tell me that they won't even practice in Claremont County before municipal court, which is misdemeanors, because it's a court that's seen as things being rigged in the back room and crony judges. So as a result of the whole situation with Jesse Kramig, there are two new judges. Nathan Little replaced Jesse Kramig. Nathan Little was appointed to replace Jesse Kramig. Katie Terpstra replaced Jason Nagel. Why? Jason Nagel, who is the judge who lied and knowingly withheld information during the Kramig investigation, is now a common pleas judge. There's also a new court administrator in municipal court, Tracy Sellers. She replaced Stephanie Boyer. Stephanie Boyer lied to cover for Jesse Kramig during a Claremont County Sheriff's Office interview and should have been charged for that. But she moved over to common pleas court and became a double dipper, so the liar now gets a taxpayer subsidized pension and a taxpayer paid salary. And these courts wonder why they have credibility issues. As a result of this, the judges, particularly Ms. Terpstra and Mr. Little, instead of trying to do something to rehabilitate their image, are now going into a mode of trying to have more secrecy and more lockdown. Rule 12 of the Rules of Superintendence gives the right of the media and frankly any citizen to record court proceedings. The judge shall allow this to take place. I'm going to in a minute play 4 hearings from Judge Anita BECHMANN's courtroom. Judge Anita BECHMANN doesn't seem to have a problem with people inspecting her work and looking at her work. And I have to say, sitting in her courtroom, she seems like she knows what she's doing. She treats people with respect, and she is professional. On the other hand, Katie Terpstra, last week, I believe it was on June 5th, outright denied my right to record under Rule 12 a hearing that took place before her. It is absolutely wrong. It is absolutely corrupt. On June 6th, I went back and tried to record in Nathan Little's courtroom. Nathan Little beclowned himself, and I'm waiting to get the audio of this, by claiming I needed to give him 24 different forms. He's just trying to throw up obstacles to inspection of him. And I think I know why. Both of these judges are crony appointments. They are untested. They don't have real experience. Nathan Little was a crony magistrate under Judge Mary Lynn Burke as a political favor. Katie Terpstra has no magistrate experience. So they both are afraid of being inspected. Neither has stood for election. Neither is going to be opposed, but both are going to be on the November ballot. And they need to be inspected more, and they need to understand there's a time with Nathan Little, he's talking about his courtroom. I'm sorry, Nathan, get your head out of your ass. It's the people's courtroom, and you're obligated to the rules of superintendence, and you're obligated to professional judicial conduct. Both Katie Terpstra and Nathan Little need a lot more inspection. They're not going to be opposed, so this is the only time we're going to have to try to get these judges to be more than hack cronies of a political system. Nathan Little for being a loyalist to the party, and Katie Terpstra for being a loyalist to the prosecutor's office. The court is moving in the wrong direction. I can't even believe it that Jesse Kramig and Nagel probably were more professional judges than these two clowns. So watch this video, though. It is 4 hearings that took place before Anita BECHMANN. Watch how she interacts. Very professional, very respectful of people. Even if you were the accused and you listen to the way she interacts with you, you'd feel good about her, that she cares about you. I'm betting that when I can actually get recordings, and I will, of Nathan Little and Katie Terpstra's courtrooms, you're not going to see that kind of professionalism, that kind of demeanor. You have people with their egos that are about ego. Nathan Little's about ego. Katie Terpstra's about fear, I think. Fear of being exposed is not knowing what the hell she's doing as a judge.
State of Ohio versus Timothy Edwards, 24 CRB 1586. That will be followed by Kevin Owens. Mr. Edwards, good morning, sir. Mr. Edwards is present and represented by Mr. Mason. The state of Ohio is represented by Mr. Kennedy. This matter is here for plea or trial setting. Mr. Mason, the paperwork I have indicates that Mr. Edwards will be entering a plea to possession of drug abuse instruments, a misdemeanor second degree. Is that correct?
That's my understanding, Judge.
And Mr. Edwards, is this what you want to do today, sir? All right, very well. Mr. Mason, what plea is offered? Mark, no contest? All right.
We would stipulate the facts constitute the offense of
Very good, thank you. Mr. Edwards, I need to review with you your plea of no contest, okay? A plea of no contest is not an admission of your guilt to possession of drug abuse instruments. It is, however, an admission to the truth of the facts that are alleged in the complaint. A plea of no contest cannot be used against you in future criminal or civil proceedings. Do you understand that? Now, if you are found guilty, you are subject to going to jail for up to 90 days, ordered to pay a fine of up to $750 plus costs, and you could be placed on community control with sanctions and penalties for up to 5 years. Do you understand those possible consequences? Is anybody at all pressuring you, threatening you? Do you feel coerced at all to enter this plea today? Do you have any conditions, physical or emotional, mental? Have you taken any substances, even something legally prescribed that might be clouding your judgment? So you're clear-headed today, sir. Are you? All right. Now, Mr. Edwards, are you a citizen of the United States? Are you on probation, community control sanctions, parole, post-release control in any other court or any other case? All right. I do have to put you on notice, sir, that a finding of guilty here could cause you to be violated in those other cases. Do you understand that? All right. Mr. Edwards, you have the absolute right to have a trial in this matter instead of entering a plea. At a trial, which you can have before the jury or the court, at a trial you would have the right to make the state of Ohio prove your guilt beyond a reasonable doubt and have this case dismissed or a finding of not guilty if they fail to meet their burden of proof. You have the right at a trial to subpoena witnesses, cross-examine witnesses, testify, or remain silent. But you're giving up all of those trial rights by entering this plea of no contest. Are you okay doing that, sir? Do you have any questions of Mr. Mason or of this court about your plea of no contest? I'll accept Mr. Edwards' plea of no contest. I'll find that it's been given knowingly, intelligently, and voluntarily. With respect to the facts.
On or about 12 2024 in town, I have deputies were dispatched to overdose and then right on scene subject matter overdose had fled the scene with a suspected based on witness statements. Later came in contact with the defendant who admitted to declaring that her surrender that was found.
Nothing other than mitigation.
Based upon my consideration of those facts, as well as my independent review of the complaint, I will find Mr. Edwards guilty to possession of drug abuse instruments in violation of Ohio Revised Code 292512, a misdemeanor of the second degree. Are we prepared for sentencing today, counsel?
Yes.
Yes, sir.
Very well. Mr. Edwards, I'm going to hear from the lawyers first, and then if you have something to say, I'd like to hear from you. Mr. Mason.
Your Honor, he's 37 years of age. He was on probation for felony matter here in Kentucky. At the time this event occurred, his overdose on June 24th of last year. He overdosed at his mother's home. She found him. I think she said she actually gave him 3 doses of narc. When he came around, he immediately jumps up and he takes off running. She had already called 911. So when the authorities, and I guess paramedics arrived, he had run off, but eventually they came in contact with him. On the basis of that, his probation officer on the Kentucky case, she violated him. He was locked up in jail jail in Kentucky. And Judge, that's how he missed the cases, the appearances on this case. Ultimately, he was released from jail in Kentucky. Our note shows that May 22nd of this year, his probation officer was squared him here, turns himself in on May 20th. Was it May 22nd of this year he finished the treatment? And that's when he turned himself in. Yes, sir. And then on May 29th, there was bond hearing, that here we are today. So his probation officer is well aware of this. He is already in treatment. I mean, through his probation.
Where,
He is still on probation.
where did he do treatment?
Go ahead. Residential.
Mine is
So do you live in Kentucky?
No, I was in the process of got like 45 days or whatever, to get transferred here.
And what I understand is he's still on probation, and I assume there's still drug testing from time to time. So I was just going to point that out, Your Honor, so that it wasn't have any duplication. His probation officer works with you here in Ohio. And then, yeah, we'll hear from you anything else.
Not yet. I want to hear from the state, if you don't mind. Go ahead.
Just trying to hold it further.
All right, thank you. Mr. Edwards, I'm not understanding the treatment stuff.
When I got this case back in last year,
I get that. I get they're transferring it, but where is it now? That's what I'm asking.
the
Treatment.
it's in Bowling Green. I just completed it on the 22nd.
So there's no transfer.
Yeah, it's in the process. I'm in the process of it. I can't do Kentucky and whatnot. They know I'm here. I have to call my PO when I leave here. I just got 45 days until I get considered here. I guess the way they explain it.
You mean the Kentucky case, the transfer, they have 45 days, and they're gonna establish Kentucky probation.
I don't know why they give you the 45 days, because they told me that it's already accepted. I just have to wait until they actually give me. I don't know what they do.
And Mr. Kennedy, are you asking that the legals be destroyed as controversial?
Yeah, Your Honor.
Mr. Edwards, I have considered the principles and purposes of sentencing. I've considered everything that's been offered today. I've considered the factors I'm required to consider in statute. Looks like you have a bit of a record here. I don't know what all the convictions are, but there are enough contacts, it's like close to 17 different case numbers and contacts that this court is concerned about this situation. You had to be Narcan 3 times in order to be brought back. That's pretty substantial. And while I know you and your attorney want me to make it convenient on you, to not have to duplicate probation or treatment, I get it. I really want to, I'm not going to put you in jail on a flat sentence, but I really want to offer you treatment, and I'm going to make you do probation, reporting probation, so that We have somebody here monitoring that you're actually doing the treatment.
Yeah,
Okay.
I have, you know,
You're on probation here too,
yeah.
Kentucky and here.
That's why I had to get it transferred here from Kentucky because of the.
Okay, okay, so it's not on another case. I was about ready to get wound up that you were on probation on another case here. So, I get it, but I'm gonna give you a probation officer out of this court, okay? All right, the sentence of the court based upon my independent review of this situation is 90 days in the Kramig County Jail. I will suspend 88 of those days and give you credit for the 2 days that you served previously, placing you on 2 years of reporting probation, Mr. Edwards. The terms of your probation are as follows. No new offenses, follow all the laws. You're ordered that you cannot consume any illegal drugs, no alcohol, no marijuana. You understand that? I'm ordering that you get a substance use assessment and mental health assessment at Greater Cincinnati Behavioral Health. I don't know what they're doing to transfer or whatever, but this assessment's going to get done here, okay? You're ordered to complete and you're to follow up with any recommendations. So if those experts tell you that you need group, that you need individuals, whatever you may need, you have to follow up. You understand? I'm ordering that you complete 8 hours of community service within 45 days, pay a $100 fine plus costs, and I'm ordering that the needles be destroyed as contraband. You understand that sentence so far, Mr. Edwards? I do need to go over with you the sanctions of your reporting probation. It's a little bit repetitive, but I need to go over those with you. No illegal drugs, no alcohol, no marijuana. Do not enter any establishments whose primary source of income is derived from alcohol sales, so you can't go to any bars while you're on probation. You understand? Successfully complete substance use treatment, mental health treatment. You're to attend sober support meetings as directed. You are ordered to submit to random talk screens and comply with any electronic monitoring or scram that the probation officer may order. Now, do you understand this sentence, Mr. Edwards? If you fail to follow the terms of this sentence, if you're violated for any reason, you could go back to jail for up to 88 days. The court could increase your probation to 5 years with additional sanctions and penalties. You understand that? All right. What you're going to do is you're going to go see the clerk. They're going to talk money with you. Then the compliance officer will go over everything, give you copies of everything, and set up an appointment with you with your probation officer. Okay? All right. Mr. Edwards, I hope you understand. I want you to engage in treatment and get better and deal with this substance use issue. I can't imagine your mother or grandmother Narcaning you 3 times to bring you back to life. Okay? All right. Thank you very much, sir. Go see the clerk. State of Ohio versus Aaron Cantrell, 25 CRE 1236. Mr. Cantrell, good morning. Well, Mr. Cantrell is represented by Ms. Donovan. The state of Ohio is represented by Mr. Kennedy. This matter is here for clear trial setting. There's a cross complaint. We're going to set those together on June the 10th at 9:30. Is that correct? Have you been down to probation yet, sir?
I did not.
I may be messed up, so. All right. Very well then. Go see the clerk and get your notice.
Sure.
All right. Thank you. Yeah. State of Ohio versus Kevin Huggins, 25 CRB 1050. Mr. Huggins, good morning. Mr. Huggins is present and represented by Mr. Mason. The state of Ohio is represented by Mr. Kennedy. This matter is here for clear trial setting. I have paperwork indicating that Mr. Huggins is going to enter a plea of guilty to theft. Is that correct, Mr. Mason?
That's correct, Your Honor, and in exchange for that, there would be a dismissal of the criminal case.
Is that right, Mr. Kennedy?
That's correct.
Officer Jameson, I just called for you and I didn't see you there, so after this case, come on up.
Thank you, Your Honor.
And that way I won't forget you. How's that?
Yes, Your Honor, thank you.
All right, Mr. Huggins, is that what you want to do? Enter a guilty plea to theft? All right, let me go over that plea with you, okay, sir? A plea of guilty is a complete admission of your guilt to theft. Do you understand that? If you're found guilty, sir, you could go to jail for up to 180 days, be ordered to pay a fine of up to $1,000 plus costs, and be placed on probation for up to 5 years with sanctions. Do you understand that? Is anybody pressuring you, threatening you, coercing you to do this today? Do you have any conditions or have you taken any substances that might be clouding your judgment? You're clear-headed? Are you a citizen of the United States, sir? Are you on probation, community control, sanctions, parole, in any other court or any other case? All right. Sir, you have the absolute right to have a trial in this matter. At a trial, to a jury or to the bench, you would have the right to make the state of Ohio prove your guilt beyond a reasonable doubt and have the case dismissed if they fail to meet that burden of proof. You have the right to subpoena witnesses to that trial, cross-examine witnesses at the trial, testify or remain silent. But you're giving up those trial rights by entering a plea of guilty. Do you have any questions of your attorney or of this court about your plea of guilty? All right, I'll accept Mr. Huggins' plea of guilty and find it's been given knowingly, intelligently, and voluntarily. With respect to the facts.
Thank you, Your Honor. On or about April 20th, 2025, in Kramig County, Ohio, in a walk two clothes in Union Township, on sign clothes, he selected a bikini sweatshirt, walked down a separate aisle, placed those clothes on in person, and then walked out of the store, passed off as the same about hanging with them.
As to those facts, Mr. Wilson.
Nothing on this fact, Your Honor, and I do believe there's no request for restitution.
That's accurate, Your Honor.
Based upon my independent review of the complaint and my consideration of those facts, I will find Mr. Huggins guilty to theft, a misdemeanor of the first degree. Count B will be dismissed. Mr. Mason in mitigation.
Your Honor, it looks like you have a credit of 8 days. As far as I know, that would be on this particular case. I know he had another case in Clark, but I think the 8 days is credited to this case. He is 61 years of age.
Mr. Huggins, what would you like to say? It's not about getting it out of the way, it's about you stopping, stealing, and trespassing. You've had 11 charges filed this year alone. I mean, what's that got to do with you committing crimes? You had 1, 2, 3, 4, 5, 6 charges last year, and 11 already this year. We're not even halfway through the year, sir. I need more than a shrug.
He's in rehabilitation, so I guess what he's saying is he didn't have income, he was obviously struggling financially, finally he now has a job offer that will allow him to get back on track.
What's the job offer? Who? Where? What's the name? He's what? Okay. And what's the address? So when's your first day of work? Mr. Kennedy, let's see, have anything?
Your Honor, just reiterate that there's no restitution. If there's a period of probation, goes to ask for a stay away.
Where are you gonna live when you get out, sir? Mr. Huggins, the court has considered the principles and purposes of sentencing. I have considered factors that I'm required to consider. The court has considered the fact that you've had 31 contacts with case numbers here in municipal court, and as I recited, 11 of them in 2025. At some point, there has to be some way to keep our community free from you and your persistent criminal activity. I get this thing that you say that, you're homeless and you can't find food, etc. But there are plenty of resources in the community without you continuing to disobey the law. You've been trespassed from Lowe's once before. You went on their property and stole again. And at this time, the court feels that you're not amenable to community control. I am sentencing you to 90 days in the Kramig County Jail with none of those days being suspended. You get credit for the 8 days that you served, and I'm ordering you to pay a $50 fine plus cost. You understand that, Mr. Huggins? While you're in jail, there are plenty of people over there that I'm sure have already reached out to you to provide you with case management services and other services to help you when you get back into the community to be able to find a place to stay and or resources for food and clothing. Take advantage of it while you're there in the jail, sir. But at least this court knows for the next 90 days, we're not going to have violations of the law. Okay? Do you have any questions, sir? All right. They have case management services to find you housing. Their program is called PATH. They also have employment services. We have a jail linkage program. That jail linkage program should be working with you unless you denied it for these 8 days that you've been there. So while you're over there for 82 more days, reach out to them. They're going to set you up with those resources. I can tell you, Mr. Huggins, I'm very familiar with what's going on here at the jail. And that way, when you come out, you'll have some assistance with continuing with this job, getting a new job, housing, and resources. All right? It's up to you, though. It's your choice. So, good luck. I wish you the best of luck, Mr. Huggins. And 24 CRV 3242. Ms. Tincher is present, represented by Mr. Shield. Good morning, Mr. Shield. The state of Ohio is represented by Mr. Kennedy.
Your Honor, just recently routine about these matters. Filed a notice of appearance of request for discovery. Obviously, we haven't had any time to discuss it, so I'm just asking for a continuance so that the state can get discovery and we can resolve
You've been
things.
down to probation already, ma'am? All right, you took the test and everything? All right, very well then. Mr. Kennedy, how long do you need?
Just a couple of weeks, Your Honor. I've got a request. I believe I have everything.
Very good. Couple of weeks, okay by you, Mr. Shield?
Yes, Your Honor.
All right, very well. Ms. Tincher, do you understand what's happening in your case? All right, I'm going to set this over for a couple of weeks. I'm going to give your attorney a chance to get discovery, review it, and then be able to advise you. And then hopefully at the next hearing, we can make some decisions on how the case is going to proceed. It's been pending. I mean, I know you weren't here, but it was filed back in November. And I'm sure you want this as well. I really want to get this under resolved or know where we're headed on it. Sound fair? Thank you. Gerald Wolf III, 21 TRC 12377. Mr. Wolf, good morning. Come on up to the podium. That'll be followed by Daniel Fondenberger. And Officer Day, I'm sorry, I want to get a couple of cases out of the way, and then we'll do that on this matter, okay? Thank you. All right, Mr. Wolf, good morning. Again, this is 21 TRC 12377. Mr. Wolf is present, not represented. The state is represented by Mr. Kennedy. Mr. Wolf, you have the absolute right to be represented by an attorney at all stages of the proceedings. You're not in any jeopardy of going to jail today because you're asking for driving privileges. The only way you would go to jail is if you act up in court today, which I don't expect. But you do have the right to hire counsel if you want to. Do you want this matter continued for counsel, or do you want to proceed without an attorney?
I would like to proceed without an attorney. I have,
Yeah, I don't want to hear about all this stuff yet. I just want to know the attorney question right now. You want to proceed without a lawyer? All right, very well. I'm going to set the stage for the record. Mr. Wolf was sentenced by Judge Miles in November of 2021 on a second and 10 OVI. His license was suspended for 5 years. At one point, Mr. Wolf had a probation violation. I ordered him into the jail to serve a full sentence on that matter. He requested privileges April 30th of this year. I set it over for hearing. And we're here now on the motion for driving privileges. Mr. Wolf, what would you like to say in support of your driving privileges?
I would like to give the documents that I have to
Okay. If you'll hold on for just a minute until my bailiff gets here. But tell me a little bit about yourself. Are you working? What's going on?
Yes, ma'am. I am 34 years of age. I am a barber. I graduate barber college on July 16th of next month. I have been rigorously working towards creating my own new life. I've now had many roadblocks that I've had to maneuver through. I've also gotten a job. I've opened up a barber shop in the town. I have a son, 6 years old. I'm in the motion right now for joint custody of him, and that's in the same county and also the same city that we opened up a barber shop in. So it's in Ludlow, Kentucky, right across the river.
Are you a resident of Kentucky now?
No, ma'am. No. I do go to school, and I'm also going to be working in the state of Kentucky, but I live here in Kramig.
Okay.
I've been taking basically careers and stuff like that because I've learned my lesson. I do have something I would like to share.
Do you want to read it aloud, or do you want to read it like that? Okay, just give me just a second here. Can you tell me what privileges you're requesting?
Yes, ma'am. I am requesting to be able to go to work and back. And also, I have 2 more weeks of school. So the time frames are different, but they're very similar. So for the next 2 weeks, I'm asking to go to school and back. And then once I start working back, and also on July 15th, that's when I go set my hearing for the joint custody case. So his school is literally right across the street from my barber shop. It's on the same road. So essentially, picking up my son to and from won't be too hard from my barber shop. It's same street, same town. And that's why I really put my feet in the city of Ludlow, is to provide for my son.
Well, some of the issues that I have, Mr. Wolf, is when you were monitored by this court, before you were found guilty, you didn't report for your test, on reporting bond. Then you were placed on probation by Judge Miles, you absconded for over 300 days, and you never finished substance use treatment. Why should I grant you privileges and put the community at risk because of your multiple OBIs when I don't know that you completed any kind of treatment?
I have completed treatment now.
Correct.
It's Brightview.
Did you have a certificate?
Yes, ma'am. I've been sober for almost 2 years now, and I've been getting drug tested for 2 years, and I have all screens up to current. You want to see my screen?
Don't take out your phone. Sorry.
I can provide them on a PDF, if they could get a, because obviously I can't do that now, but.
Just hang on just a moment, sir, I want to read your letter.
Absolutely. So. I do have another one from my boss and head instructor. He's my instructor in the school, but he's also my boss of the barbershop.
I'd like for you to address something else. About a year and a half ago, or 2 years ago, you got a driving under OVI suspension.
Yes, ma'am.
What was going on there?
That was right before I saw you.
So, on one hand, Mr. Wolf, we've got an issue of you didn't really comply well. When Judge Miles sentenced you, gave you an opportunity at probation, you didn't comply. You absconded for a long period of time, didn't complete the substance use program that the judge wanted you to complete. You also violated the rules to not drive by being convicted of driving under OVI suspension. On the other hand, looks like you've completed some substance use treatment. Looks like you've tried to turn your life around by becoming the type of dad that is asking for now custody or joint custody of your son, that you engaged in changing your career and developing a business.
I have that as well, so,
I don't know. It's okay. I trust you on this. What I'm trying to say to you is there are a couple of things to consider. Combined with your OVI history, this is a matter of serious concern for the safety of the community. You've had multiple OVIs. At the same time, you have made some changes in your life for the positive that I want you to consider. Are you still at the Hopewell Avenue address? Very good. Mr. Kennedy, does the state have a position? Thank you. Here's what I'm going to do. I'm going to take this under advisement. I want to thoughtfully consider it. If I do a knee-jerk reaction, Mr. Wolf, I'm likely to deny your request. I want to review your driving record, which I have. I want to review these letters. I want to review your history and make a thoughtful consideration about whether to grant you privileges. I want to tell you, if I do, it will be more limited than what you have here, and it will involve the use of the ignition interlock device. You understand? All right. Give me about a week to thoughtfully consider it. I'll send a written decision to you in the mail.
I can also provide my screen to you if you would like me to, dating back for almost 2 years.
I think that would be good, and I think it would be good if I had a certificate from Brightview. There's a compliance officer up there in the front of the clerk. If you get that information, you can't do it by phone, you have to print it off. If you bring it in during normal business hours, give it to the clerk, or the compliance officer, let her know that Judge Beckman asked you to bring that to her, and she'll put it in your file for you. Very good. Appreciate your patience this morning, sir. Good job on some of the positive things that you're doing. I hope you understand what I'm trying to do is consider where you're at now versus where you're at on paper.
Absolutely.
All right, and at the same time, I hope you understand the weight that I am on my shoulder about safety community, the safety of the community.
Thank you, ma'am. My mother is a public servant, and she said, once you have these DUIs, and say I were to, slip up, they go after a judge, and so I do understand the weight that you as a judge should hold.
Well, it is about those innocent persons that may be hurt as well, so, all right. Very well, sir. I'll issue that decision in a week if you get that paperwork.
Yes, ma'am.
Good luck to you, sir. Thank you. Daniel Fondenberger, and then that'll be followed by Jaden Helms. And I want Mr. Barnes and Mr. Perry to know that you're on deck for your couple cases down, okay? Thanks for your patience.